Okay, this is going live. I'm ready to go. Good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing, but should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf, or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you could remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person would not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Finally, I need everyone to raise your right hand for me, please. Do you swear or affirm any statements you make during this proceeding shall be the truth, the whole truth, so help you God?
Yes.
Okay, let's start on the ladies' side with Tadrika Gibson.
Okay, sit down.
Miss Gibson, ma'am, you're charged with one count of simple assault, family battery. That is a misdemeanor. Bond is going to be set at $3,000 for that offense. You're also charged with one count of family violence battery. Bond is going to be set at $5,000. That is also a misdemeanor for a total bond of $8,000. There's going to be a stay away provision on this bond to stay away from a Michael Bryant. Do you understand that?
Yeah.
Your preliminary hearing date is going to be set for April 5th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. It looks like you refused to fill out the form. You plan on hiring your own lawyer?
Yes, I already have a lawyer.
Okay, what's your lawyer's name?
Thomas Florio.
Okay. Was he expected to be here today?
I talked to him before I got arrested, but I haven't talked to him while I was down here.
Okay. Well, make sure you stay in contact with Mr. Florio. Do you have any questions for me, ma'am?
No, sir.
Okay, ma'am, you're free to go back.
Thank you.
You're welcome. Next, we have Katisha Gregory. Miss Gregory, ma'am, you're charged with 1 count of possession of cocaine, simple possession. That's a felony offense. Bond is going to be set at $3,000 for that offense. You're also charged with 1 count of use or possession of drug-related objects. Bond is going to be set at $1,500. That is a misdemeanor offense. So you're going to have a total bond set at $4,500. Your preliminary hearing date is going to be set for April 4th at 8:30 in the morning. Courtroom 201, that date will get waived upon your bonding out, and you'll get a new court date in the mail. You've also refused to sign the form. Are you going to hire your own lawyer?
No, sir.
Are you going to represent yourself?
Yes, sir.
Okay, do you have any questions for me?
I don't have any money for it. So will I be in here until I get the money? To actually.
You will remain in custody until you post bond, ma'am.
You can't call.
Then I get probation?
Ma'am, I'm not here to conduct a trial of your case or to take a plea in your case. I'm here to
So I have to
set
pay.
bond. Ma'am, listen, I'm here to set bond. I'm here to give you court dates, and I'm here to see if you need an attorney. Those are the 3 reasons that I'm here.
So I will have to pay $425.
Whatever arrangements you make through a bonding company, or you can put up property, or you can post the total amount cash.
Okay.
Okay, any other questions, ma'am?
No.
Okay, you're free to go back. Next, we have a Danetta Lovelace. Miss Lovelace, ma'am, you're charged with 1 count of theft by deception as a felony offense. Bond is going to be set at $5,000. You're going to have a preliminary hearing date set for April 4th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Looks like you make a little bit too much money to qualify for a court-appointed attorney. Are you going to hire your own lawyer? You're going to represent yourself?
I'm gonna hire me an attorney.
Okay. Do you have any questions for me, ma'am?
No, sir.
Okay, you're free to go back. Next, we have Alicia Richard. Miss Richard, ma'am, you're charged with 2 driving-related misdemeanor offenses. The first charge is driving a vehicle with no tail lights. Bond's going to be set at $500 for that. And you're also charged with driving a vehicle on a suspended license. Bond is going to be set at $1,500 for that. So that's going to be a total bond of $2,000. Your preliminary hearing date is going to be set for April 5th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, I filled that form out. And I also, the ticket itself said that it was for my actual tag light, not the tail light. So it was the light that was above my tag, but my tail lights were active.
That is what is on the warrant. What's on the bond order, it says no tail light. So I'm just reading what is on the bond order, but what's on the warrant, it does say defective tag light.
Okay. So
Okay, but either one would be still $500.
Okay.
So the answer is yes. You want me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, ma'am, you're free to go back. The next person is out to bond, Galvez Torres, Torres. After Ms. Torres, we have a Ms. Wright. Spencer Wright.
Sincere.
I'm sorry, ma'am, how do you pronounce your name?
Sincere.
Sincere?
Yes.
Okay. Ms. Wright, ma'am, you're charged with several drug-related offenses. At this point, I'm denying bond on these offenses. Under warrant number 50829, you're charged with possession of marijuana with intent to distribute, which is a felony offense. Under warrant number 50630, you're charged with possession with intent to distribute MDMA. I'm denying bond on that offense also. On warrant number 50832, you're charged with possession of a sawed-off shotgun, which is also a felony offense. I'm denying bond on that charge. And finally, warrant number 50831, you're charged with possession of firearm and knife during the commission of or attempt to commit certain felonies. I'm denying bond on that offense also. Your preliminary hearing date is going to be set for April 4th at 8:30 in the morning, courtroom 201. I'm going to also set a bond hearing date for April 8th at 8:30 in the morning, courtroom 201. And practically these will be done by Zoom. However, I'm still putting the courtroom down in case we're back in court. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, I'm going to find that you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
How quickly would I be able to see this lawyer?
So the appointment happens today, and it'll be with the Public Defender's Office of Clayton County, assuming there's no conflict. I'm assuming they're going to see you relatively quickly. I don't work for that office, nor do I work, nor do they work for me. So I can't tell you exactly when they will come out. I'm certain they come out every day or they make arrangements to meet with their clients. So the short answer is it'll most likely happen this week, but I would just be speculating for you if I told you an exact day or time. Okay.
Yes,
Anything
sir.
else, ma'am?
No, sir.
Okay, ma'am, you're free to go back. Finally, we have Miss Guinness, who's here on a fugitive from justice warrant. Okay, Miss Guinness, ma'am, you're here on what's called a fugitive from justice warrant. All of the same rights and privileges that I discussed previously apply to you, but you're in a slightly different category. Clayton County is simply holding you because there is a warrant for your arrest out of Alabama. And okay, so have you already discussed whether you want to waive the hearing or not?
I want to wait for them to come pick me up. Yes, sir.
Okay. Do you have any questions about this process?
No, sir. The investigator explained to me that I would sign this paper, they would forward it to Alabama and give them 10 days to pick me up, and then they could get an extension of 21 days. So basically they have 30 days to pick me up.
Okay, so the statutory period is 30 days. Now, if that's something that they do as a custom between sheriff's departments where they try to pick people up within 10 days or not, I have no understanding about that. The statute says that they have within 30 days of the signing of the warrant to come and pick you up. Okay?
Yes, sir.
They can request an additional 30 days if they don't come within the initial 30 days. And I say that because it could be customary, it could have some kind of standing. I don't work within the fugitive department. The fugitive people discuss things with fugitive people all the time, just like judges discuss things with judges all the time. I cannot tell you that there's going to be 10 days and then they're coming to pick you up, because that's not the statute.
Yes, sir.
Okay. Are there any other questions, ma'am?
No, sir.
Okay. Once you sign off on the waiver, you'll be free to go back. They'll send it over to me. I'll sign it and the clock will start to run today.
Yes, sir.
Okay, ma'am, you're free to go back once you sign the waivers.
Yes, sir. Do I need to sign it?
Yeah, you can sit down.
Okay, let's switch over to the mail side.
Okay.
Okay, so let's see, the first person I have on the mail side is a Fernando Arnold, who I'm showing as being OTB. And the second person I have is a Zachary Bixler, who's also showing as being OTB or out to bond. So the first name that I have is Justin Borba, B-O-R-B-A.
He's here, Your Honor.
Okay.
Hello, Your Honor.
Hello, Mr. Borba. Sir, you're charged with one count of trafficking marijuana. This is a felony offense. And in the state of Georgia, any amount of marijuana that is alleged to being trafficked over 10 pounds, I cannot set bond at this proceeding. So bond is going to be denied pursuant to statute 17-6-1. You're going to have a preliminary hearing date set for April 4th at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing date set for April 8th at 8:30 in the morning, courtroom 201. Now, is it your intent to hire your own attorney, or do you want me to see if you qualify for the appointment of an attorney?
I'd like to see if I qualify for one for now.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, I mean, just being that this is my first offense, I was wondering if there was any possibility for bond, but I understand under Georgia law that that's not possible.
Exactly. I would be breaking the law if I set a bond on this offense. It's totally taken out of my hands.
Understandable, Your Honor.
Okay, you're free to go back, sir. The next person I have is a Mr. Carlton, Jalon Carlton.
He's here, Your Honor.
Okay. Mr. Carlton, sir, you're charged with 3 misdemeanor offenses. The first being possession of marijuana less than an ounce. Bond is going to be set at $1,500. The next charge is use or possession of drug-related objects. Bond is also going to be set at $1,500. And finally, driving a vehicle without valid insurance. Bond is going to be set at $1,000. So you're going to have a total bond set at $4,000. Your preliminary hearing date is going to be set for April 5th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
Okay, I'm going to find that you qualify, Mr. Carlton. I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir?
How do I find out if I bond out today?
Okay. Are you asking, will you be able to bond out today?
Yes.
Yes.
And somebody just let me know.
Okay, so what you're going to have to do following this hearing, Mr. Carlton, is you're going to have to start making arrangements to get yourself out of jail. If you don't make those arrangements, you're just going to sit there until you turn old and gray. Okay, so you start making the arrangements to get yourself out of jail. And when the paperwork get processed, which when this hearing is over, I start doing the paperwork, I send it over to the jail. They then start inputting it in system. If you're doing what you're doing and I'm doing what I'm doing, hopefully by the time both of those things are done, they're knocking on the door telling you your bond has been paid. Okay? All right, sir. Free to go back. Yes, sir.
Sorry, Your Honor. How much was it altogether?
$4,500. I'm sorry, $4,000.
Thank you.
Okay, sir, you're free to go back. Mr. Copeland?
How you doing this morning?
I'm doing well, Mr. Copeland. Sir, you're charged with one count of criminal damage to property in the second degree, which is a felony offense. Bond is going to be set at $3,000 for that. And one count of hit and run, leaving the scene of an accident. Bond has been set by schedule at $1,500. So that's a total bond of $4,500. Your preliminary hearing date is going to be set for April 4th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah, I do.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
I do have a question for you. With it being my first offense, is there any way it could be more lenient on the 3,000? And also, I did return to speak to the lady that ran the property that day. So it's not like I left. The only reason I left is because my radiator was leaking, and I had to go get it fixed in Atlanta, and I came on back. So actually try to fix. I'm a welder, and it was a gate. So I did try to fix it. I did try to come back, and I did speak with the property manager, and I came back 2 days after that, and to go over it. So.
Okay, so I normally set the bond at $5,000 for criminal damage to property in the second degree.
Okay.
Anything else, sir?
So what's my total?
$4,500.
All right, thank you.
Okay, you're free to go back. Next, we have Mr. Hurd. Mr. Hurd, sir, you're charged with one count of financial transaction card fraud. This is a felony offense. Bond is going to be set at $5,000. You're going to have a preliminary hearing date set for April 4th at 8:30 in the morning. Courtroom 201, that date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
That's fine.
I'm sorry, sir. I can only understand yes or no.
Yes, sir.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Next, we have a Mr. Hernandez.
How you doing, Your Honor?
I'm doing well. Mr. Hernandez, sir, you're charged with one count of loitering or prowling, one count of entering an automobile, which is a felony offense, and one count of obstructing an officer. I've dismissed the obstructing an officer charge. There's a $1,000 bond set on loitering or prowling. I'm denying bond at the moment on this entering automobile. There's a warrant for your arrest out of DeKalb County for failure to appear. You're going to have a preliminary hearing date set for April 4th at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing date for April 8th in courtroom 201 at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, I'm going to find that you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
So how long be doing for the felony?
Well, I've appointed a lawyer to represent you. The lawyer may be able to work something out to get you a bond on this case. As I indicated before, you do have a warrant for your arrest out of Decatur for failure to appear. And that's one of the bases that I'm using as to not grant bond on this felony offenses that you have.
Yes, sir. Yes, sir. I got stopped by Riverdale police, and they said that DeKalb County, they didn't want it. So I was trying to figure out what was going on with that warrant in DeKalb.
Okay, well, it's still showing in the system as an active warrant.
Even if they didn't come get me that night?
Did you try to go to Decatur and get it taken care of?
No, sir.
Okay, it's still showing as active. I can't, I don't know who this person is that you're telling said that they called the cab and the cab said they're not going to do it. It's showing in the system as an active warrant. That's the only thing that I can rely upon.
Yes, sir. I got stopped. It was a sheriff from Flint. I mean,
I understand. I understand. Do you understand why that's not going to change my mind?
no, sir.
It's showing as an active warrant in your criminal history.
Okay.
So, had you immediately booked from that interaction with that officer, called over to the cab, hey, this is showing an active warrant. I don't have an active warrant. You did not do that. So it's still showing as active, sir. That's
Okay.
all I can act on.
Yes, sir.
So what may you do differently after now? This is the second time that you're being told that there's an active warrant in the system for your arrest. Are you going to duck your head in the sand, or are you going to try to take care of it?
I'm gonna take care of it because what happened was I didn't think it would matter. So I just left
Okay,
it
but it
alone.
does. It
Yes.
does. It does, especially when you're seen by witnesses in somebody's car with an active warrant for failure to appear out of another jurisdiction. I mean, you may want to start slowing down a little bit.
Yes, sir.
Okay. All right. Anything else, sir?
So just wait for a lawyer, right? That's it.
Yes, but I would encourage you to try to deal with this. I don't know if you have a lawyer in DeKalb on this other offense or whatever, but sticking your head in the sand is only going to get you just riding around on prison transport buses. That's
So,
all I'm gonna tell you. I
yes.
said sticking your head in the sand is gonna
All
get you
right.
riding around on prison transport buses. Okay. All right, so you're free to go back.
All right, thank you.
You're welcome. Mr. Jones.
Good morning.
Good morning, Mr. Jones. Sir, you're charged with committing five offenses. One is a felony. The first is possession with intent to distribute marijuana. I've set the bond at $10,000 in recognition of your criminal history, which is relatively light. You're going to be charged with one count of use or possession of drug-related objects. Bond is going to be set at $1,500. That's a misdemeanor. The first charge is a felony. You're also charged with speeding. Bond is going to be set at $500 for that. You're charged with driving too fast for conditions. Another misdemeanor. Bond is going to be set at $500. And you're also charged with driving a vehicle without having your license on person. Bond is going to be set at $1,000. So that's going to be a total bond set at, I believe that's $13,500. Your preliminary hearing date is going to be set for April 4th at 8:30 in the morning. Courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Now, you didn't fill out the form. That means you're going to hire your own lawyer.
Yes, I have an attorney.
What's your lawyer's name?
Counselor Hope, it's McHood, it's MACFOOD, McHood. It's pronounced a little strange.
Okay. And you said Hope?
I can't remember the first name. I just learned about it last night, quickly over the phone.
Okay. And I was just asking because if it was Hope, I was going to ask if she was expected to be here today, or
She was expected to be here today, but I'm not sure what happened. She was supposed to contact me earlier this morning, but I didn't have any contact.
okay. Well, make sure you tell her that you have been granted bond, that you have a preliminary hearing date for April 4th at 8:30 in the morning. But like I indicated before, that date will get waived upon your bonding out, and you'll get a new court date in the mail.
And
Okay.
bond is 10,500.
Okay, so your total bond is going to be set at 13,500.
13,500.
Yes, sir. Anything else?
No, sir.
Okay, you're free to go back. Mr. Lee? Mr. Lee, sir, you're charged with 4 driving-related offenses. The first is driving under the influence of alcohol to the extent it made you a less safe driver. Bond is going to be set at $5,000 for that offense. The second charge is improper lane change. Bond is going to set at $500. The third charge is impeding traffic. Bond is going to be set at $500. And finally, the last charge is possession of less than an ounce of marijuana, which is a misdemeanor offense. Bond is going to be set at $1,500. So you're going to have a total bond set at $7,500. Your preliminary hearing date is going to be set for April 5th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir, and I have a question.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Now, what's your question?
I was taking the other Southern Region Medical after I was arrested. And my blood work and my urine sample stated that I didn't have any controlled substances in my body. You know what I'm saying? I have documentation from that, but you know what I'm saying, my blood work and my urine sample stated that I had no alcohol or marijuana in my system at all. That's why he said that what the officer told me when he wrote it up as a DUI, but I was sleeping. I wasn't under the influence, but he said that it was gonna be a misdemeanor DUI.
Well, all DUI, unless it's a habitual violator, all DUIs are misdemeanors. That is some information that you really need to share with your lawyer. This is not, like I said, this is not the point to have the trial. The officer at the point that you're arrested on a DUI charge, when it says DUI alcohol less safe, it means that the officer believes that you're under the influence of a substance to the extent that it made you a less safe driver. Doesn't mean that you're under the influence of a substance. I try to remind people all the time, everybody that goes to trial and are found innocent, they went through this process. Does that make sense to you?
Yes, sir.
Okay. Anything else?
What's my total bond?
Let's see. 7,500.
Okay.
Anything else, Mr. Bradley? Mr. Lee?
No, sir.
Okay, you're free to go back. Mr. Moore?
Good morning, y'all.
Good morning, Mr. Moore. Sir, you're charged with 1 count of felony possession, simple possession of cocaine. Bond is going to be set at $3,000. There's an indication that you're wanted out of DeKalb County, that there's a warrant for your arrest. So you need to be aware of that even posting bond here, you're most likely going to have to go to DeKalb County to deal with that. Your preliminary hearing date is going to be set for April 4th at 8:30 in the morning, courtroom 201. If you're still in custody at the time that hearing date comes about, then you'll have your preliminary hearing. Would you like for me to see if you qualify for the appointment of a lawyer?
I would, sir.
I'm sorry, sir.
I would, sir.
Thank you. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, free to go back. Mr. Swanson.
Hello, Your Honor.
Hello, Mr. Swanson, sir, you're charged with 2 misdemeanor offenses. One is driving under influence of alcohol to the extent that it made you a less safe driver. Bond is going to be set at $5,000 for that offense. The second charge is improper lane change. Bond is going to be set at $500 for that offense. So you're going to have a total bond set at $5,500. Your preliminary hearing date is going to be set for April 5th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Now, it looks like you didn't fill out the form. You're going to hire your own lawyer?
Yes, I will.
Okay. Do you have any questions for me, sir?
As far as the technicalities of the charges that I was charged with, should I wait to my preliminary hearing to speak on those issues?
Well, short answer is that once you bond out, you're not going to have a preliminary hearing. Your case is going to get bound over to state court. Best practice is not to say anything about your case until you've had an opportunity to speak to a lawyer. Because you're a layperson, you may say things that you think are, I've had people say, well, yeah, I took this, but I didn't take that. And they're on probation. So now they put themselves in jail thinking that they were getting themselves out of jail. Okay.
Gotcha. Okay.
All right. Anything else, sir?
No, sir.
Okay, you're free to go back.
Thank you.
You're welcome. Mr. Walker. Mr. Walker, sir, you're charged with one count of theft by taking, being a U-Haul rental. I'm going to set a bond at $10,000.
Excuse me, sir.
I'm going to set a bond at $10,000. This is a felony offense. You're going to have a preliminary hearing date set for April 4th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir. May I speak on this case for a matter?
Mr. Walker, have you heard me deny anybody the opportunity to speak after I've spoken?
No, sir, I haven't.
Okay, sir, then calm down. You're not any different than anyone else. Do you want me to see if you qualify for the appointment of a lawyer?
I also keep clicking the handcuffs, making it hard for me to hear you, sir.
You
Yes,
can always ask me to repeat a question.
okay, could you?
You're not saying I can't hear you. You're saying, can I speak? That clicking the handcuffs doesn't equate with can I speak?
Yes, sir.
All right. You do qualify, sir. I'm going to appoint a lawyer to represent you. Now, before you start speaking, you have to understand that you've gotten off on a bad foot with me as it relates to credibility. So if you're going to try to get me to believe something, you may want to speak to your lawyer first.
Sir,
Okay, go ahead.
my my bond is higher than I can afford. Also, that's honest. Also, I was this warrant was never took out the system. I was picked up on this warrant on the 23rd of January, and I was released on the February 2nd. This is in Fulton County. I was arrested by College Park like I was tonight. Well, like I was yesterday. College Park arrested me. So I'm asking that, is there anything we could do, sir, to kind of check into why I was picked up again, or just, could we get this bond reduced? Because at the point, I'm going in between employment, school, and housing issues, and I was.
Okay, now, Mr. Walker, you made some factual statements that I'm going to ask you to repeat if you so desire, because what I heard you say doesn't fit with what I understand the facts to be. So do you want to run them dates by me again?
Yes, sir. I was arrested on the 23rd. I was released on the 2nd.
Okay, wait a minute. There's a 23rd of every month. I need a month, a date, and a year.
This year, I was released on the 2nd of February. And it was January.
Hold on. You were arrested on what month?
Last month, January, for the same warrant. So,
sir, please. The reason I'm asking this is because you're not making sense to me. So please answer the question I asked. You were arrested what month?
January.
What day?
on the 23rd,
What year?
this year, 2022.
For this charge?
Yes, sir.
Do you know when this warrant was obtained?
I was arrested by
You-
officers. Do I know when the warrant was obtained? They
Yes, sir.
Yes or no?
No, I don't know what this one.
Okay, so Mr. Walker, this is why I tell you to speak to your lawyer first. This warrant was obtained on February 3rd of 2022 at 1:13 p.m. by Officer Josh McFadden.
That was after I made bond out of Rice Street. I released from Rice Street on the 2nd of this month, February. On the same charge, thereby taken for the U-Haul. The College Park police locked me up in the U-Haul. I had a reservation for it. Long story short,
Sir,
I went to.
say this from your attorney, okay? Explain this to him. Do you have any questions for the judge?
Yes, I do, Judge, sir.
Yes, sir.
This case needs to be dismissed. I already did 10 days on this case.
That's not a question. Do you have any more questions for the judge?
May my bond be reduced?
No.
And why is getting this locked up for the same one? And may I use a phone call? They haven't let me use the phone yet. I've been here over 12 hours, haven't been able to use the phone yet. So may I use the phone? And may I see a lawyer? I mean, I honestly not lying. I was locked up. I'm calm. I'm cool, calm, collective. I just couldn't understand because the only thing I did, tried to go rent a U-Haul to tow my truck because Charles Walker called me for the code enforcement. He called me and asked me to move my truck. I went and moved my truck. I got locked up, that's the truth. I was arrested last January. This year, January, on a Saturday.
We're talking about the case.
No,
Yeah.
this is the same warrant.
I know, but that doesn't pertain to what's on right now. All right, say that for your attorney.
Okay, hold on. Let me read this to Mr. Walker. Because Mr. Walker, you got to understand this isn't the time to have the trial of your case, and you're trying to plead your case. And my job is to let you understand why you're being arrested. Okay. On Monday, January 24th, I, Detective Jay McFadden of the City of Morrow Police Department, received and reviewed a recovery checklist for a stolen vehicle, a 2009 Ford Econoline, Arizona tag AD 88890. The vehicle was recovered by College Park Police Department on January 23rd, 22nd, and was impounded to Moody's Record Service at 3845 Conley Street, College Park, Georgia. I met with Herbert Hall at U-Haul, the complainant, at 1549 Mount Zion Road, who reported the vehicle stolen, advising Mr. Hall the vehicle had been recovered and was at Moody's record. While speaking with Mr. Hall, he was able to give me a copy of the council contract for the U-Haul that was stolen with a copy of the Georgia driver's license with it. Mr. Hall gave me a copy of a Gerard Walker and stated he was the male who took the vehicle from the parking lot without permission. I contacted College Park Police Department in reference to the stolen vehicle that was recovered. College Park advised that the driver of the vehicle was a Gerard Walker and was arrested. I requested a copy of the incident report, but however, the report was not in the system at the time of the request. So there's nothing that you're telling me that is out of line. It's just kind of not in line with what is in this warrant. So that's why you're in custody. That's why you're arrested for that. I understand that you disagree with it. You're not supposed to agree with it. You stand here an innocent person. That's why we appoint lawyers so that you can sit down with your lawyer. You understand what you're being charged with, and you and your lawyer can talk about a defense. It's not to sit here and try to plead with me to help you to get out. I set a bond that I believe is reasonable based upon the allegations. And I do believe this to be reasonable.
But, okay, yes, sir. I thank you for clearing that up for me, but you do understand, I feel I've been arrested twice on the same charge.
You have, but you've been arrested in 2 different jurisdictions. So what happens is, if I am wanted or alleged to have committed a crime out of, so let's say this vehicle is reported stolen. You're in Fulton County. The Fulton County police officers see the vehicle as being reported stolen. They pull it over. They don't take you to Clayton County. They arrest you being in possession of the stolen vehicle and take you to the jail of that county, which is Fulton County. So you're correct. You were arrested then. But the complaint is out of Clayton County, which is where the case will be prosecuted. So once the officer knew that you had been arrested and in possession of the vehicle in Fulton County, they get a copy of the information. The person in Clayton County says that's the guy that took the vehicle. So then he came and got warrants for your arrest for actually taking the vehicle and not being in possession of the vehicle.
It got returned on the same day I was arrested. I had
Okay.
reservations for booking.
So Mr. Walker, do you really believe that sitting here having this conversation is going to change my mind?
No, I know it's not helping me because your decision is made. I never understood that I could get locked up that way. Like the Cottage Park police locked me up. And then there's a warrant come from Plain County, but they take me to Fulton County. I had to sit up there and bond out on the charge. I'm a free man for 3 weeks and get locked back up on a warrant that is void because I've already been fingerprinted. I got fingerprinted again on the same warrant description. The same warrant description. And I have reservations for that vehicle. I did not steal, take nothing.
Okay.
I mean, I just need, it's cool you say August 4th, right? So I should have stayed in Fulton County and went to court from up there.
No, you should have got a lawyer.
I got a lawyer. They gave me a public defender lawyer.
You,
See, now you say I'm in another jurisdiction. Now I got to deal with Plain County jurisdiction. But in Fulton County jurisdiction, I have an attorney for the same warrant that the police locked me up for the night when I was only trying to pay for a hotel room.
in Fulton County, you're charged with being in possession of stolen property. In Clayton County, you're charged with actually taking the property.
Both of the charges that I taken.
Okay.
They said grand larceny it was larceny when I got here, it turned to theft by taking or so. The warrant said larceny.
Mr. Walker, for a person that professes to not understand the law, you seem to know a lot about the law.
Because I've been staying out of trouble, Judge. Your Honor, I've been working for myself and for the municipalities. And I do a nonprofit. I'm not trying to get in no trouble. I'm being sensible as possible, civilized as possible. I got an injured foot and everything, like for real.
No, I believe you, Mr. Walker.
I'm not.
Mr. Walker, we have enough lawsuits against the jail, Mr. Walker. I don't need you falling over right now trying to show me your foot. Mr. Walker, mistakes happen all the time. I understand that. Whenever we're talking about a vehicle, my bonds start at $10,000. So I need you to understand. And the reason because people are like, why that is, and this is a business, so it's not necessarily the same thing, but we don't have good public transportation here. And this doesn't apply to your situation, but vehicles are important to people. And in this instance, the way that it's written, there may be something that your lawyer can deal with, but you got to get to the lawyer and look at the stuff and have it to be dealt with. You already have a lawyer in Fulton County. Reach out to that lawyer, okay?
I gotta go to court 2 times. Don't tell me I got this double jeopardy now. Feel me? One warrant, 2 counties. What they do? What they do that?
Mr. Walker, you could be going to court for 50 times. I don't know how many times you're gonna go to court.
But no, did you understand? 1 charge, 2 jurisdictions. Do I go to 2 courts? No. I ain't
Okay,
no lawyer, but-
okay, Mr. Walker.
Who made the mistake then? Cottage Park?
I don't think anybody made a mistake. If honestly, I think you made the mistake.
I take my hit, but I done already been hit. That's what I'm
But
saying.
you just said who made the mistake, and now you say, well, I take my mistake.
Yeah.
Sir, it began with you. Mr. Walker, I have one more
charge,
person.
sentence.
Mr. Walker,
It 1 charge, 1 sentence, Judge.
I cannot enter these bond amounts. See, you'll be the same
Ain't about the
person.
bond amount. You
Mr.
cool.
Walker,
I'm
Mr.
talking about me
Walker.
coming down here when I was already been up there.
Your Honor, do you still need Mr. Walker?
I want the bond to be reduced, but
Hold on. I just put you on mute, Mr. Walker, because I need you to understand this. You're the same person that'll be in jail until tomorrow complaining that you can't make bond because the paperwork is being held up, not knowing that a person like you, Mr. Walker, has been sucking up all the time because you're trying to get a bond reduced, and I've told you it's not going to get reduced. So you can keep asking me to reduce it. You're muted, sir. Nobody can hear you. You can keep asking for the bond to be reduced, but it's not going to be reduced. Is there anything other than asking me? Hold on. Do you have any question other than how many times am I going to go to court? Whether double jeopardy applies? Whether my bond is going to be reduced? Do you have any other question other than those 3? Because I've answered those. The deputies will allow you to use the phone. They go on their own internal policies. I'm not the sheriff's department. You will be allowed to use the phone. But the first time that I say, yes, you're going to use the phone, you'll be telling the deputies, the judge said I can use the phone. So that's why the response is you will be allowed to use the phone. It's related to the sheriff's department's internal policies. Speak to them. Okay, Mr. Walker, you're free to go back. Let's bring in Mr. Williams.
How you doing?
Okay, I'm doing well. Mr. Williams, you're already in custody, correct?
Yes, sir.
Do you have a lawyer already?
I have a paid lawyer for my case that I'm already in here for. I don't know. I haven't spoke to him about this situation because I haven't had the chance to because I'm in a hole for the current situation right now. So I do want to see if I can get appointed a lawyer until I contact him because I haven't been able to contact him.
Okay, I'm going to appoint a lawyer to represent you. You're charged with 1 count of aggravated assault and 1 count of aggravated battery. I'm denying bond on both of those offenses at the current time. You're going to have a preliminary hearing date set for April 4th at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing date set for April 8th at 8:30 in the morning, courtroom 201. Do you have a bond set on your other charges?
Yes, sir. I have a bond set for all of them, which is 100,000.
Okay.
May I ask a question too, sir?
Yes, sir.
I was trying to see, because
You can't leave.
I'm supposed to go to a superior court in a possible 2 weeks. So I was trying to see if I can already get the case handled with Robert Judge Mack, because that's my judge, that's my superior court judge. So if it's a chance that I could get, if it's a chance that you could see if Robert Mack could handle this situation as well as everything is in a hole.
It should follow, this case should follow your other case.
Yes, sir.
Under the way that they deal with case assignments. Since you already have an open case before Judge Mack, this should go to him. And depending on whatever arrangements you may make through your current lawyer, this may be able to get combined and dealt with at the same time.
You saying that's meaning as running concurrent, right?
No. I'm saying like both issues are dealt with.
At the same time.
Right, instead of having, oh, well, he was in court on Monday and then he's coming back on Wednesday or he's coming back on Friday. And that's up to Judge Mack and the lawyers that are going to be involved in that case as to how they want to address it or deal with it. So don't take this as my saying that that's what's going to happen.
Yes, sir.
But this case should go with Judge Mack.
Yes, sir. Yeah, because I supposed to be going in like 2 weeks because I already agreed to time serve on everything that I was already locked up in here for. So that's all I was just trying to see if that the case was going to be handled with the other charges that I'm already in here for.
Okay,
All right, thank you.
you're welcome. You're free to go back.
All right, appreciate it.
Okay.